Hi, I'm attorney Mike Walls from Maronick Law Offices. We're here to answer your questions.
Okay, Mike, I have a DUI. What do I do? What are my options? And what's the difference between a DUI and a DWI?
Well, that's a good question. Let me begin by explaining the difference here in Maryland between a DUI and a DWI. Um, First, I think it's important to note that shorthand for DUI is shorthand for driving under the influence of alcohol. DWI, as you can imagine, is driving while under the influence of alcohol, driving while impaired, rather. The difference is the extent of any impairment by alcohol. That's really the difference. You can consider that the DWI is when you're not quite as inebriated as a DUI. Maybe you just have a little buzz or whatever you want to call it, as opposed to someone who is under the influence for the DUI. One of the things we want to make sure our clients understand are the elements of each of those offenses. And so that's one of the first things that we do. Let's take, for example, a DUI. In that case, the state has to prove, in order to find you guilty, they have to prove beyond a reasonable doubt that you were driving a motor vehicle on a public highway in the state of Maryland while your ability to operate that vehicle was influenced by the use of alcohol. The state can also make that same case under a certain section of the DUI law in Maryland if you have taken a breath test and you have blown over a .08 on the test. That is a driving under the influence per se, or it just is a per se proof of you being under the influence of alcohol if your test result is of that nature. In a DWI, the state does have to prove that your ability to function is impacted or impaired in some way by the use of alcohol. And that's the difference. There's also a major difference in the penalties associated with these two offenses. For a DUI, you face the possibility of 1 year in jail and a potential $1,000 fine. That also carries with it some collateral consequences. The major impact of that would be 12 points on your driving record if you're found guilty of that offense. For a DWI, the penalties are a little bit less, 60 days and a $500 fine for the judicial penalties. The collateral consequences associated with the DWI are 8 points assessed on your driving record. So these are very serious offenses. The thing that is important for anyone to note in Maryland when you get a ticket for a DUI or a DWI, there is always a component associated with a breath test. Typically what happens is if you're pulled over, the police officer has reason to believe that you may have been drinking and driving. You're asked to provide or perform a series of standardized field sobriety tests. That often includes putting your finger to your nose or following a pen, walking a line, saying the alphabet backwards, standing on one leg. There's a number of these standardized field sobriety tests. Based on your performance, the police officer may very well ask you to do a preliminary test on the side of the road. That's where you just blow into a little device. It can't be used as evidence against you, but it does give the police officer additional evidence to consider when he or she is considering giving you a ticket for a DUI or a DWI. If you're arrested, you're often then taken back to the police station, where you're given a very long, somewhat convoluted advice of rights form to read through and decide whether or not you want to take a breath test. The long and short of it is that if you refuse to take the test, you're subject to a suspension of your driver's license here in Maryland of up to, it's for 9 months or 270 days. If you take a test and you do okay on the test, but you still blow more than a .08, you're subject to a 6-month suspension of your driver's license. If you blow a fairly healthy reading on the test, which is a 0.15 or more, you're subject to 6 months suspension of your driver's license. The difference between a lower score and a higher score there is that if, for instance, you blow a test result of 0.08 or 0.14, you can get a modification of any suspension. That's sort of a fancy way of saying that you can go to the Office of Administrative Hearings if you request a hearing and get a license to go to work or to school. We used to call this in the olden days a bread and butter license. You can go to and from work, go to school, you can go to doctor's appointments, you can go to alcohol classes and that kind of thing. You can do that as long as your score is not above a 0.1 or 0.15 or above. Now, the key here is if it is above the higher limit or you refuse to take the test, we will seriously examine the advisability of enrolling in the Ignition Interlock program. If you've had any friends or family members who have had these before, they're often referred to as a blow and go, which means you do have to blow into a tube to verify that you have not been drinking, there's no alcohol in your breath before your car will start, and that's going to be for a period of a year. That's often sometimes the best option for some people. We will go over all of those considerations when making that decision. But here's the key. If you want a hearing to determine whether you're eligible for a work license or if it's advisable for you to enroll in the Ignition Interlock program, you must act immediately after getting the tickets. Call our office. The law is very, very clear that you have 10 days to ask for an MVA hearing. You only have 10 days to do that. If you miss that deadline, there are certain things that you would otherwise be entitled to that you're no longer going to be entitled to. So it's important to call our office right away after you get these tickets so we can assess the best way to proceed as it pertains to the breath test and some of the MVA consequences, the administrative consequences associated with a DUI. We will certainly go over the procedure, how these cases are handled in court, and give you a basic overview of how things are going to proceed. We will also explain to you what may be a likely outcome if, for instance, on a first offense, often we find that the courts are willing to give our clients a break in terms of the sentence in the case on a DUI or a DWI, and that is often the judges will offer our clients what we call probation before judgment. That's PBJ, shorthand. That means there's no conviction and there's no record. Consequently, the MVA is not notified of the court action, and there are no points associated with the disposition in the court. So that is very much to your advantage. Often is associated with the probation before judgment is a period of probation, some alcohol classes, maybe some Mothers Against Drunk Drivers activities, and some other associated terms and conditions. But that's probably something you could consider as a potential likely scenario for a first offense DUI. I will tell you that the potential penalties for anything other than a first offense DUI or DWI are fairly serious, often will include jail time. It is absolutely imperative, no matter whether it's your first offense or second or third or subsequent offense, it's absolutely important for you to call our office, talk to one of our attorneys about what you need to do to protect your rights and get the best possible disposition for this case. Thank you.